I'm looking forward to getting together with you all in person again at the Flight Club, if for no other reason than just to trade war stories. And I think that one of my favorite mediation war stories had to do with a very unusual project where we represented the owner, and the contractor had some employees who were doing really dangerous things. I won't get into what it was, but unusually dangerous things. And we, for various reasons, were able to get that on videotape, but nonetheless, we weren't able to get through to the decision makers who might have been able to negotiate some sort of a pretrial resolution until we were about a year and a half into the litigation. And the darndest thing happened when we finally got together, and this is at the close of discovery, expert reports had been disclosed. We get the ultimate decision maker, comes to Chicago from a couple of time zones away, and he brings in a bunch of decorations that he won when he was in the Vietnam War, and they were truly impressive. And he looked at us and he said, how could an American hero like me, be guilty of running a company along the lines of what you allege? And, I said, well, I got it on videotape right here, and I turned it on, and the case settled. And I'm sure that when we get together at Flight Club and at other times, we would be able to trade hundreds of similar stories. But I think that what we all know is that cases resolve or don't resolve for the darndest reasons, and it often has very little to do with what people write in mediation or pretrial briefs. So with that introduction, I'm pleased to have a chance to chat with you here today. I'm pleased that my mentor Paul Lurie is on the call, because he's certainly the father of guided choice. And I was having lunch with Dan Rosenberg a couple of weeks ago, and I asked him whether it was okay if I give an impassioned presentation today that might get me kicked out of SOICA. And he said that I should go ahead and feel free to do that. I should preface this all by saying that this is just one lawyer's opinion. I certainly don't have all the answers, and what I don't know greatly outweighs what I do know. But I do feel really passionately about this because of my background. And in the first 4 years of my practice, before I lateraled to Schiff Hardin, I worked for a firm where we did large loss property subrogation on the plaintiff's side, and everything that I recovered was on a contingency fee basis. So I learned really quickly that I didn't get kudos for winning a trial after 3 years. I got kudos for getting the case settled in 3 months. And so that was my focus for the beginning of my time as a litigator. And then when I made it to Schiff Hardin in 2006, I found both a practical and a philosophical framework to go with this instinct that I had to try to get cases settled early. Practically speaking, it was a variety of Schiff Hardin members who were members of SOICA, many of whom are on this call right now, just seeing the way that they conducted themselves in front of some of the best mediators, the Jonathan Markses and the Eric Greens. But the philosophical underpinning of all this, I really have to credit to Paul Lurie. And I was greatly influenced by some of his collaborators with guided choice mediation. Jeremy Lack comes to mind. He's a mediator, I believe, in Switzerland, and Francois Bogaz, who I believe is active in France and Portugal as a mediator, who really writes interestingly about the application of neuroscience to negotiation, conflict resolution, and management. And if you take in some of Francois' materials, you really can't help but think about how the emotional and the cognitive parts of our brain are literally in a fight with each other at a wide variety of times, certainly in mediations, for oxygen and glucose, and they can't work well at the same time. The mere mention of the word loss, I'm told, triggers a reaction, an emotional reaction in the amygdala. And so I think there's a wide variety of things that can cause people to settle or not. I think it's uncontroversial for everybody on this call that it's seldom what people write about in their mediation submissions. And it was true with the longest piece of litigation that I ever had. It was 9 years long, and the only thing that was preventing a settlement was there was an insurance mistake made when the contracts were written up. So all of the positions that we took substantively in negotiations, they really meant nothing. It was something else that was holding up the negotiation. And there's a wide variety of things that can serve as impediments to settlement. And, again, they're not the things we write about in our briefs. Lawyers' intuitions certainly can prolong litigation. I think we're all a little bit guilty of optimistic overconfidence and perhaps a tendency to pay selective attention to facts depending upon which eye we want to have closed and which we want to have open. And there's a whole variety of other things that for purposes of brevity I won't go into here, but it's not the things we write about in our mediation submissions. And so what I'm hoping to accomplish today is to focus mostly on the core principles of guided choice. And you'll see that I'm not referring to it as guided choice mediation, because I think that guided choice dispute resolution goes beyond just mediation. One of the things that has been drilled home to me for years, thanks in part to Paul Lurie and in part to some of my other mentors at Schiff Hardin, is trying to understand what do business people think about when they try to conceive of whether they should make a business decision to settle or not. Of course, we'll do a comparison to the traditional mediation process, and then I might get on my soapbox a little bit if there's time and talk a little bit about how I try to use these principles as an advocate, even though it's often the case that there's no one else who's involved in the dispute that's interested in thinking about the kinds of things I'm going to review today, and it's often the case that not even a mediator or a neutral who would be involved in the case would be thinking at all along the lines of what we're going to cover here. And I think that what we're going to discuss today is the blinding flash of the obvious. The bad news is I don't think I'm going to tell you anything that you don't already know. Certainly when you go to the doctor, there's a diagnosis, prescriptions written, there's a process that's run of trying to heal the patient. If there are problems, they're anticipated, and eventually there's a resolution. And here with guided choice dispute resolution, I think it's the same kind of idea, with the rub that one of the things we want to try to avoid more than anything is a premature negotiation. I think that those tend to be the mediations and the negotiations that fail, when people are forced to talk about dollars and settlement before they are ready to do so. And in spite of the fact that I think there's probably wide acceptance of the idea that what I have up on the screen here would be a good thing, the most interesting question to me is why is there so little adherence to these kinds of concepts? I think generally when we get into a mediation, one of the first things we do is we pick a date for the mediation. It's thought of as an event that happens on a date certain, and a lot of times we'll show up at the mediation. Parties won't have the information they need to make a business decision about whether to settle or not. There will be a positional negotiation with people being on far ends of a spectrum. Fists are pounded on tables, Danishes are consumed, and people often leave unhappy. And I'm certainly not trying to change your negative feelings if you have any about mediation. I have them too. I have tons of frustration with mediation, at least some of the ones I've participated with in the past. But I think that confirmation bias, certainly with mediation, is real. People tend to find information that favors or confirms their existing beliefs. And I'm sure you, like me, have dozens of reasons to dislike mediation. But I do see some interesting cognitive dissonance, the state of having inconsistent thoughts, beliefs, and attitudes, when we try to hold in our minds at the same time the idea that, mediation's a waste of time, which I think a lot of people believe, and they've got this confirmation bias. Everything they see around mediation tends to reinforce that. And I think where the cognitive dissonance lies is that if it were you who were involved in a dispute, I would be willing to bet that most of the people on this call would not pay lawyers like us 6 or 7 figures only to litigate to a pre-trial settlement. I think that if it was your dispute and you were the principal and it wasn't a construction matter that you can handle yourself, if it was some other area, I think that you would look for a back door to come in. You look for the short way around the block. And I think what's interesting is that is, in many cases, not something that we do when we're representing our clients. And what I have here on the next slide is what I think is one of the most important and impactful things that I've ever heard said in my 21 years of being an attorney. And I credit something like this to Paul Lurie. I believe that I heard him say something like this for the first time. And it's really changed the way that I look at the practice of law. And he said something like, smart business people are asking, why do we pay so much to prepare for trials which seldom occur? And I think that that is a really interesting question, because I think we can all agree that nearly all civil litigation revolving around design and construction ends in some sort of a negotiated resolution that is pre-trial. And I think that this question is going to be asked increasingly, because I think we're in a new era. I remember at the early part of my career getting banker's boxes, Rule 26A disclosures and discovery. But we're in a new era of AI and ChatGPT, where information is abundant for our clients too. You know, the information that we need to resolve disputes, I don't think is any longer locked in a law library that only we can access in paper form. You know, our guild of attorneys and the role that we have as gatekeepers between the information that our clients need to access, I think is changing. And I think that we need to prepare for hard questions to be asked of us in the future. I don't know that the era of unlimited hourly billing to litigate to pre-suit settlements that happen late in the day in the life of litigation is likely to continue. And because of the high settlement rates in litigation arbitration, you know, I think that we are going to see clients asking us questions that have been drilled into me by Paul Lurie. I can see clients asking us, you know, what value do we get from you to pay you to prepare a case for binding dispute resolution using these time-consuming adversarial tools if we know the case is likely to settle? You know, and if there's a good answer to that question, you might be asked, why didn't you also initially discuss with us options for settlement processes to run in parallel with your trial prep that might avoid the most significant costs? You know, and I think we might need to be prepared to answer questions like, you know, why do companies who use your competitors, other attorneys, get the info that they need to make a business decision about whether to settle or not, or perhaps to change their position more quickly and with less expense? And certainly, if I was the client, I would be asking these questions and possibly getting rid of a lot of lawyers who didn't have good answers to them. And I guess the question is, and it's kind of the elephant in the room, you know, what is it about litigation that when it becomes mature that makes people want to settle? And, you know, I'd argue that there's nothing magic that happens in discovery, you know, and only occasionally in litigation, you know, if there's some dispositive ruling that is important. I would argue that civil litigation is perhaps the most inefficient means of information exchange that's been devised by humankind. And just like you know, we're no longer, you know, cavemen, and our cravings for salt don't serve us anymore, and we, you know, don't have wisdom teeth for any particular reason, and we, you know, have our appendices out if we get appendicitis. I don't know that some of the old way of thinking continues to serve us anymore. Certainly, you know, when the Seventh Amendment was passed, codifying the idea of civil jury trials as part of the Bill of Rights in 1791, I think the world's changed a lot. Costs of electronic discovery, for example, were not in mind. And certainly in the late 80s and early 90s, as we all saw construction mediation becoming more prevalent, I think the big question to ask is, you know, why don't we begin the settlement process earlier in the life of litigation? And I'm going to get, you know, onto some of the meat and potatoes of guided choice as quickly as I can here. But I think, you know, that lawyers' resistance to these early cost-efficient ADR procedures might be born of the idea that an adversarial information exchange, discovery, and courtroom, you know, back and forth is the best way to convince other parties that their positions are untenable. And, you know, I think it's a lot of this optimistic overconfidence in the merits of our own clients' positions. Again, you know, we've got one eye covered because we want to pay attention, selective attention to the facts that are most useful to us. You know, and I think that these, you know, instincts lead lawyers, I believe mistakenly, to think that mediation is a waste of time. But almost inevitably, we all know, as the parties get close to trial, their attitude about risk changes, especially the risk of losing and not recovering their legal and you know, court expenses if they were counting on recovering them. You know, and we've all seen how dim many judges view the option of clearing their calendar for a month to deal with a very fact-intensive, legal-intensive trial. You know, and we've all certainly experienced, you know, getting a lot of pressure, forced into litigation, by judges at the end of cases. And so, I think that, there's a lot of incentives for lawyers to think about some of these things that Paul Lurie has drilled into my head. I believe that clients will reward lawyers who can get them earlier, less expensive resolutions that can reduce the toxic effect of unresolved disputes that pend for long periods of time. And certainly as we are all pushed more towards not to exceed arrangements for billing or other sorts of fixed fee arrangements, I think that there's a real incentive for us as well. So without further ado, these are some of the core principles of guided choice. I've seen it sliced and diced a lot of different ways over the last, 15 or so years. Sometimes there's 3 principles, sometimes there's 7. I like these ones. This presentation is very influenced by an article that Paul Lurie wrote with his collaborator, Jeremy Lack. And we're going to review all these in detail, but early commitment to mediate is something that I think is important. Talking about resolution before costs get out of hand, and importantly, not necessarily focusing on getting to a dollar resolution quickly, but again, starting off focusing on process issues, creating a good process. The confidential discussions with the neutral are something that are a feature of guided choice and traditional mediation. But what is unique to guided choice, I think, is diagnosis. Looking for the neutral to really try to figure out why have the parties reached impasse, and then the neutral can design a process and generate options based upon that diagnosis. There can be a limited information exchange, which I think is important, because when parties say they're not ready to negotiate, I think that what they're saying is they don't have enough information to make a business decision about whether to settle or not. And then I think there's an important role for the neutrals to play in anticipating what would be the bases for impasse. And again, it might not be what's written in the briefs. It might be that the information that the decision makers need is not filtering up to them because the people who are their subordinates are concerned about their bonuses or their jobs. There's a variety of things. I gave you my, American hero war story analogy at the beginning of all this. Certainly there was an impasse to settlement there that had nothing to do with what I was getting out of a witness in a 12B6 deposition. It was the decision maker was checked out in a couple of time zones away. And then importantly, negotiation, but not premature negotiation when the parties are ready to actually make a business decision to settle or not. And then, the ongoing role of the neutral if negotiations are suspended and if the parties are forced to retreat, into litigation or arbitration. I think that, clients' perceptions of winning, or what is a good result can be very different from us lawyers. When a settlement is in a client's best interest, whether it is, depends upon many business and psychological reasons besides the strength of the case. Who's getting the blame? Who's getting a bonus? And I think that these factors are often overlooked by counsel, and many mediators who focus on litigation-based risk analysis. I think that this is one of the reasons why lawyers may be reluctant to recommend mediation or any real settlement process until we, get into discovery a little bit further on. But I think it's undebatable that most of the disputes we handle are not litigated or arbitrated to a binding outcome. I think it's undeniable that preparing for trial or arbitration in this age of electronic discovery is very expensive, and those costs accrue in direct proportion to how long the dispute lasts. So I think that we could say earlier is better when it comes to dispute resolution, and I think that we could say that without the need of suggesting that there has to be baby splitting or one party surrendering in a way that's against their interests or any sort of blind love of mediation. I think that instead, the reason why disputes settle later in the day, later in the life of litigation, is that there are unique aspects of the dispute which, when identified, eventually lead the parties to settle. And the earlier they're identified, the more likely impasse can be resolved the earlier the settlement, the lower the cost. And this requires a new and different approach, process heavy for every case. And that's what guided choice is. It's not traditional mediation. It's a customizable, process-driven approach that is bespoke for each case. And the beauty of it is that very little is needed. Any mediation clause in your existing contracts will suffice when you add it to the two other ingredients you need, which is an advocate's commitment to insist on guided choice dispute resolution procedures, and then a mediator that understands and is willing to run the guided choice process. Guided choice is not new. I think Paul Lurie would be the first person who would admit that he did not invent this. I think it's a collection of the techniques and practices that, in my view, are used by the best mediators out there. And I think Paul once said something to the effect of guided choice is just a new way of introducing the best practices that are used by the best mediators to a broader audience. So, how does it differ from traditional mediation? I think that in traditional mediation, one of the first thing that happens is you pick the date for the negotiation, and again, you're pulled like a tractor beam to a certain date where, if the case doesn't settle, then, the mediation fails. And when settlement is reached in traditional mediation, it's often because the mediator is respected as an expert on the substantive issues, or the settlement proposal is sufficiently attractive, but in many cases that is not the case, and the parties wind up having to move on to, this dispute resolution that, almost always results in some sort of pre-suit settlement. And I think that with guided choice, if you're trying to avoid that premature positional negotiation, what you don't want to do is convene negotiations too early. And guided choice even recognizes that in some circumstances, a party's willingness to entertain the idea of having a neutral try to run a guided choice process does not equate to automatic agreement to have a classic mediation day. Deciding when and whether there should be any dollar negotiations is something that needs to take place in the early phase of guided choice. What should the process be? And the mediator is able to, get at this by having confidential discussions, putting the brakes on getting into any specific mediation session too soon, coming up with this process design, working to make sure there's buy-in with the various parties, having this information exchange, thinking about what could cause impasse, and then getting into the negotiations, when and if it's appropriate. And so I think a lot of people say, well, why not just allow litigation or arbitration to run its course? And I want to just say parenthetically, I am not against litigation or arbitration. I represent plaintiffs and defendants in litigation now and I always will. And I think that if there's a good reason for there to be an arbitration or litigation hearing that goes to binding resolution, then it's great. If a patent needs to be busted so it doesn't hang around for 20 years, you go to trial. And, if it's a personal injury case and I'm the plaintiff and I value my damages at $50 million, but the settlement offer is $50,000, we're going to trial. And if someone's trying to lock me up and send me to jail in a criminal prosecution, maybe we're going to trial. And certainly with mechanics liens and insurance coverage deck actions and mortgage foreclosures, there's tons of reasons why you need to have litigation. But oftentimes the disputes that we litigate are just about money. And if we're honest with each other, not a lot of money. I think in the grand scheme of things, 10, 20 million bucks, it's not a lot of money. Okay? And one of the differences here from a lot of other types of litigation is I think that certainly the people who are on this call, if we took truth serum and we sat down and we spoke to each other, we would be able to fast forward the tape to the end. And with, we start off knowing 80 or 90% of how the case is likely to resolve, and then we spend, 80 to 90% of the costs associated with dispute resolution trying to find that last 10 to 20% of information, and you don't really learn anything important. Quantum is a great example. I think that most of the people on this call, due to the doctrines around how you measure damages in design and construction disputes, we could have an understanding about what are people's best and worst days. We can quantify damages, perhaps in ways that people who are not litigating design and construction disputes can't. I would argue that although discovery can help parties better understand the strengths and weaknesses of their arguments, clarifying these strengths and weaknesses can tend to only escalate to an impasse as each side props up its strengths in the hope that doing so will overcome its weakness. This results in that expensive and time-consuming discovery that is conducted on an adversarial basis. And I think that lawyers are really poor predictors of outcomes, and I don't know that this is all that controversial, although it's difficult to quantify. I do remember being amazed in law school when we did a decision chart analysis, and there were questions asked of people, tell me if we say that this case has got a very high degree of resolving favorably, rate on a scale of 1 to 10, 10 being, your case is as strong as can be, and 1 being as bad as it can be. What does it mean? What number would you ascribe to the idea that the case is really favorable? Some people, came with a 9.5, and other people came with a 6.5. So I think that lawyers are poor predictors of outcomes, and I think that we don't necessarily communicate effectively with our clients about what is the likely outcome of the case. Again, I think that there are more efficient means of exchanging information, because business decision makers don't need all the information involved in a dispute. They just need to know enough to make a business decision about whether to settle or not. So again, the 3 things that are required for there to be a guided choice mediation, the one essential element is just an agreement to use a qualified neutral to act as a facilitator. Although this person acts essentially as a mediator, his or her focus is not initially on settling the case, right? It's about process. So we need neutrals who are committed to the process, and we need advocates who are committed to the process. And to effectively implement guided choice, a mediator should be prepared to be creative and to play a role that's different than in traditional mediations. No shuttle diplomacy on a single day of mediation, but instead, understand the subject matter of the dispute and be trained to investigate and diagnose the real causes of impasse. And this training should teach mediators to recognize things like, psychological factors, risk attitudes, emotions, understanding the business consequences of settlement, personal animosities, financial difficulties, and other issues. Being sensitive of gender and cultural issues. And so I think it's important to get the right kind of mediator, and they have to be a good salesperson of the process, because if I'm lucky enough to get a mediation convened and I have a guided choice mediator that's helping us, they still may need to help to educate the other party about why are we simply not going to pick a mediation day and having what often breaks down into one of those positional settlement negotiations with people staking out extreme positions that don't tend to get cases resolved. So now I want to go ahead and go into these 6 core principles that I showed on an earlier slide as quickly as I can to fit it within the time slot. So a commitment...
Jeremy, can I ask you a quick question?
Yes.
It's Kevin Colton. How you doing? Good job so far. Really nice. If I decide I like this concept, is it possible to introduce it once you start going down the path of like what you would consider traditional mediation and you start throwing out ideas? Because my biggest concern is if you're trying to change the paradigm a little bit, this is hard for some people who don't understand the difference to really grab onto. So in your experience, do you start out with, I want to try to do something a little different, here's some things to think about, or do you kind of just get into the mediation of like maybe that first meeting with the mediator, and then you start to introduce some of your concepts from the previous slide?
Well, as one of the great mentors of my legal career, Kevin, I'd like to hear your opinion on this as well, since I've learned so much for you over the years. But I think that, my mentality is this. if I'm lucky enough to get the other side to agree to a mediation, I'm going to the table, whether or not it's a guided choice mediation or not. Certainly if it is a bet the company dispute, then I'm going to go out and I'm going to find a mediator and try to bring him in and try to get the process started from the beginning. And in the event that is not possible, but if we do have a mediation, I will start to really bend the ear of the mediator. And I can think of a few people who are on this call right now, a few highly regarded mediators around Chicago who are plenty annoyed with me from the way that I want to try to force some of these things to shine a light on them. And in the event that I can't get buy-in from the mediator, then I try to do what I can to try to diagnose impediments and to try to go right after the issues myself, even if I'm the only one there. So I don't think it has to be buy-in from the beginning. It's certainly better, but I'm always going to try to run some of these principles and thought processes, even if I'm the only one that's doing it. Is your experience different, Kevin?
Oh, I was on mute. No, I think because I've kind of stumbled into some of these ideas, because I didn't call it this, but I'm kind of trying this approach on a big mediation we have coming up. So but my concern would be if I tried to introduce it as kind of a different approach to mediation, the other side may have just put the kibosh on it right then and there. So I'll let you know how it turns out, but some of these points are things that I think make a lot of sense, especially in certain kinds of cases.
Well,
hey, it's Cliff. I'm going to jump into a little bit, because Jeremy, thank you for doing this. And I think for a lot of us who have been dealing with the complex construction cases for lots of years, this is a lot of what we've been doing with mediation. But I think what I've seen is that mediation is really all about risk analysis. And I think the primary goal is how do you get to the place where you can engage in a good, rational risk analysis. And so, so Kevin, I think that might be a way to help people understand if they're not understanding. It's like we want to get to a mediation and we want to be able to engage in risk analysis. And how are we going to get there? And then I think this all flows from that because we need enough information. Maybe we don't need all the information, but we need enough information to be able to engage in risk analysis, including, in our cases, a lot of times you need some level of expert analysis enabled to really be able to see what would be presented at trial so that you can look at your risk. All right, I'm going to stop. Thank you.
Well, you raised...
There's another aspect. There's another aspect of this issue that pertains to the insurer and getting the insurer to commit to the process. How do you pull them in?
Yeah, these are great questions, Lurie, and certainly if there are insurers involved, it can be more difficult. I do think that, what Cliff mentioned is really important as well, that there is often in these complex cases, certainly you need to have one or more experts, multiple. And again, it gets back to process because, if what we wind up doing is we exchange position statements where you have experts that commit themselves to a position in writing, it's kind of like they lash themselves to the mast. And if they deviate in any way from what their, opinions were, it's, fate worse than death for them. They're embarrassed, and so people tend to get entrenched. And so I think one of the things that Paul Lurie would, mention is maybe you get the experts together in a way and you foster a discussion before they commit anything to writing and they commit themselves to positions, because I think that, that's one way where you can possibly avoid people getting entrenched. And it all comes back to the idea of process and getting back to Kevin's point about, how do you sell this sort of thing? One of the beauty parts of all this is that if you mediate process issues before we try to talk about getting to a dollar value settlement, I think that you can create a cooperative negotiation atmosphere early on. I think procedural issues tend to be not contentious if they're approached as a means for triggering cooperative behavior, and allowing people to have a choice in deciding on the processes that they view as being in, their best interest. I think most parties have an immediate mutual interest in retaining more control over the outcome and reducing their costs. So, and a mediator can build on those common interests, set common objectives, and try to pursue joint problem solving and solution oriented thinking. And so, because we're not setting a mediation date, because there isn't even necessarily a commitment for there to be a mediation date where you've got their traditional shuttle diplomacy, when you start off at the beginning focusing on the process, I think that is a way, perhaps, Kevin, that we can try to align mutual interests and sell people on these ideas, and serve some of the concerns that both Cliff and Lurie brought up. I think that one of the things that Paul has drilled into my head, is that whether we call him a neutral or a facilitator or a mediator, the most important settlement tool is his or her ability to explore the reasons for any impasses in settlement under the umbrella of mediation confidentiality. And, verbal communication over the telephone with stakeholders is important because it tends to be more candid and spontaneous than formal written communications. And I think that disputes are more likely to settle when the parties understand the reasons for impasse and why disputes have remained unresolved despite any prior negotiations. By exploring general background in discussions privately with the mediator, the key protagonists and stakeholders are able to step back and maybe gain a better understanding of what's happened in the past and to think about what could happen in the future. But it's certainly not just saying, let's run a conflict check, let's pick a mediation date, let's exchange briefs, and then on to the next one if we don't get the case settled. Instead, in this phase, mediators act like human and social psychologists and investigators, interviewing a wide variety of participants to understand their basis for impediments and potentially future impediments to settlement. That's interviewing lawyers and insurance claim representatives and others with an interest in the outcome of the disputes. And I think that the objectives of this diagnosis phase is to identify who needs to participate. Insurers, third parties who might not be obligated to mediate, let's get them in. What are the peculiarities and the biases in play with, the corporate or governmental cultures, of the real decision makers, and what information needs to be exchanged or obtained to influence settlement positions, and then what you lead to is a process that's designed on the diagnosis to prepare the parties to get into meaningful discussions. I'm going to skip ahead here right now. I had a few dozen questions that I would love a mediator to ask me, which almost never happens at this stage, but I'm happy to chat about that offline. I'm trying to not run over here. And after understanding the basis for resistance to settlement, the neutral development's suggestions for what a process should look like. This isn't the spiel that the mediators go into, every time, right? It might be narrow tailored discovery, that focuses on deadlines and budgets and, appointment of experts for complicated disputes, as we were discussing earlier. One of the key things that the neutral's going to do here is, what if scenario planning. What is going to happen when we get together and people's ability to be rational or hijacked by the emotional side of their brain. What if an impasse develops over legal, factual, or damage calculation issues? What if you got an insurer or a subrogate that disagrees with what's going on? What if the person who's involved in the litigation doesn't have the requisite settlement authority? What if the project is ongoing and you have to deal with project issues, not dispute issues? And I think that discussing these issues and trying to reach agreement with the neutral privately before our brains are hijacked by emotion is a time when we can, cooler heads can prevail. Because there are often invisible financial or insurance issues or status issues that have been not properly considered or engaged in the process, without thinking about those roadblocks, before, we, start trading numbers, it can be really important, right? Because at this stage, we know there can be strong emotions, feelings of angers between the parties or even their lawyers. Sometimes we feel the other party is not dealing in good faith, or we feel like we've not been treated fairly or professionally. We might feel like we've been cheated or lied to, and when these feelings are involved in a traditional mediation, where the mediator brackets the party's position and tries to narrow gaps, I think that the mediation can be doomed. And, avoiding these kind of pitfalls is possible by exploring with the facilitator, the neutral, some of the social and emotional factors, some of the things that we have on the screen here right now, and we can generate new, procedural options. Maybe there's a breakfast between the principals before the lawyers ever get together on a mediation day. There might be a long feeling of a good relationship between 2 or 3 people on different sides. Let's get them together. Let's have them, have breakfast. Let's have them shoot the shit and remember they like each other. There's a whole variety of things that, a mediator could do, to create a useful settlement process based on their diagnosis of what has led to past impasses and what could lead to some in the future. I'm going to skip ahead here a little bit more because I'm trying to be mindful of the time constraints. And then we have an information exchange in accordance with an agreed process, right? I think that we can all agree that when, business decision makers say that they're unable to make a decision about whether to settle or not, I think that one of the things that they're saying is they don't have enough information to evaluate what's in their strategic best interest. And so an important question for the neutral to try to get at is, do the parties have equal access to critical outcome relevant information without further discovery? If the answer is no, how can we have a limited information exchange that can be accomplished quickly without a lot of unnecessary expense? This can be very important for thinking about matters of valuation. In this diagnosis phase, we're trying to figure out the process. The facilitator might get at the fact that the parties have been using different methods of determining settlement values, which may cause them to be very far apart in terms of dollars. And it might be the case that the mediator works with the parties and their experts to come up with some sort of consensus methodology, that would involve an information exchange and a meeting with the experts, and to try to understand what are the key variables that may be key components in, valuing settlement, ranges. And so, again, these are all things I think that are not best achieved when we just pick a mediation date and the parties write their briefs, and we all know that what's written in the briefs have nothing to do with what's really causing people to be stuck on the positions they're on and unable to settle on their own. Okay, and so it's important, I think, to think about process before you think about getting into negotiations. And I think it's really important to have the guided choice neutral anticipate and overcome, or at least try to understand how to overcome impasse, right? Because when we're talking about process, we're talking about information exchange. Passions are not inflamed, but they certainly could get inflamed as we get a little bit deeper into negotiations and we start talking about dollars, right? And sometimes some of these issues are so overwhelming they impair the party's ability to summon the cognitive part of their brain and to think beyond them. These issues, their brain gets hijacked. And so, trying to understand, maybe we're just going to carve certain issues out and refer them to an expert. Maybe we get our experts together to come to some consensus. If that won't work, maybe there's a third expert that would come up with a non-binding opinion. These are certainly things that I've seen that are helpful. And then negotiations beginning only later when the parties have what they need. But certainly I think what's really important to bear in mind, and it's the last slide, is that when an impasse happens, whether it's one that was anticipated or not, I don't think that this is a reason to terminate the settlement process. Guide and choice instead contemplates possibly adjourning the negotiation process, and then thinking about what are other things that we can do, and it might be seeking outside opinions from judges or arbitrators or experts on a binding or non-binding basis if there are really key dispositive issues. And it might be the case that the neutral would suggest that the parties actually commence litigation or arbitration in order to take a few key steps and have these issues resolved before they resume negotiations. But there's a lot of upside to keeping the guided choice neutral involved, even if negotiations are temporarily suspended. As long as the neutral continues to have the parties' trust, I think there's seldom a good reason to not have them involved, even if the parties feel that it's in their most strategic interest to retreat into their default binding dispute resolution processes and resuming battle. Sometimes the settlement process isn't linear, and it requires the suspension of negotiations for the dispute to mature, and the ongoing availability of the neutral can serve as a useful reminder to the parties that channels of communication that might be helpful for settlement are open, at all times. And certainly, arbitrators or judges might be reticent to discuss with disputing parties things like, you might win, but you're going to litigate to a Pyrrhic victory, or it doesn't matter what you argue, I've already decided that, the other party's in the right. And, they're not necessarily going to discuss these things with us. But if there is a guided choice neutral that is orbiting around in arbitration, maybe in touch with the chair of the panel, maybe there's an opportunity for there to be meaningful discussions, that would be in everybody's best interest, but otherwise wouldn't come about, unless there is this third party that stays involved. And from an advocate's perspective, as I said at the beginning, I'm a fan of mediation. I know it's a controversial opinion. I ask 5 lawyers who get 10 opinions, and I'm certainly not here to convince you that you should like mediation if you don't. I do believe that the days of us, litigating to pre-suit settlements after charging our clients 7 figures of attorney's fees, I think those days are over, or they're going to be over soon. And so anytime that there is somebody who's willing to mediate with me, anybody wants to have a table and invite me to sit with them to discuss negotiation, I'm going to sit there. Even better if I'm able to implement a guided choice process. And so, I'm always looking for the right opportunity to use guided choice. The truth is that I probably am able to run it in the true sense of the word maybe 1 time in 10. But that doesn't mean, that I'm not always trying to take the best of this and to use it. And so I look for neutrals who understand and espouse the principles of guided choice mediation. And I know who they are. And they're not necessarily people who we run into in Chicago. I've gone as far away as Washington, D.C., and I've imported a mediator in from Chicago in a bet the company dispute where I needed to not be pulling the mediator along on my back trying to get him or her to do this. I wanted a mediator that would be shot out of a cannon and do this anyway. So if I'm lucky enough to be able to set the table right, to use guided choice, I'm going to look for a neutral that's going to espouse and understand its principles. And, I'm happy to hear this from a mediator, even in Chicago, that might be unable to run a traditional guided choice process, because I'm looking to run the process to the greatest extent possible. I don't care whether we pick a mediation date on the first day, if that's what's expected by the other side, as long as the mediator understands that my expectation is that they're going to work hand in glove with me to try to get at the things that have caused, the true things that have led to an impasse to date, and then what could lead to an impasse in the future. I'm going to run this by myself even if the mediator won't. I'm going to run it with the mediator if they're willing, even if the other parties won't. And I'm always willing as an advocate to be ready to fast forward the dispute to the extent that I can, or pause as is most strategic for my clients. One of the things that I've really taken a shine to doing in the last couple of years is I'll collect all of the relevant electronically stored information from my clients' key custodians well before I file a complaint, and I'm going to pick what I think is most important for the other side to see, and I'm going to stick it in their face. pre-litigation. Because why, if I believe that this is the thing that is going to cause them to settle, why should I wait 2 years from now? If I was a personal injury lawyer that was looking to ring the bell at trial, maybe I save back my best arguments to the end. But I do the opposite. I like to put them, in people's face, and not just philosophically, but I'll gather up my clients' emails and I'll study them and put my best arguments forward. But sometimes the opposite opinion, the opposite approach makes sense. I had a very long mediation that lasted for years with a mediator who I think is on this call, and the principal party that I was working with on the other side is also a SOICA member on this call. And the other lawyer raised a great point, something that warranted me going back with my expert and answering the question that he raised in order for him to be able to get his insurer past their hangups. And I paused the mediation for 6 months and I worked with the expert in order to deliver that information up, and it eventually led the case to settle. So I'll fast forward, I'll pause, and I will stick to or abandon guided choice as is strategic. And you can see on the right side of the screen, this is kind of where it ends for me. I'm going to size up the dispute. I'm going to decide whether I think a true guided choice process can work or not. It's my practice these days to know more than anybody I'm going up against before I ever get into a mediation. I think that one of my former mentors at Schiff Hardin used to say that you bring a knife to the mediation to figure out if you need to bring a gun to trial. I gather up the information. I'll know more. I will very politely shoot to kill, in pre-mediation negotiations and certainly at mediation, meaning that I'm going to go for the Achilles heel and not save it up. I'm going to assess the other party's needs to try to meet them. And then, we will settle or not. And I will never split the baby or give up my client's strategic best interest only to settle. There's no virtue in that. That is a very brief overview of a topic that I think we could talk about for weeks at a time. And I look forward to doing that with you over beers when we're all together shortly. And I think I may have used up all the time, but I'm certainly happy to hang around and chat with anybody that finds any of this stuff interesting.
Yeah. Can I just, there was a wonderful presentation. The standard question is, where do I find a guided choice mediator? And increasingly, you will see them on their resumes that they follow the principles of guided choice, which are published by the American College of Construction Lawyers, which has endorsed guided choice. In fact, ACCL has published a major paper, which is available to the public on their website. But the most important thing you can do is not only look at the resume, but to interview mediators before they're hired and ask them the question, what processes do you use? And if all they do is talk about old-fashioned, facilitative or not, or things like that, you don't want those people. You want people who say, I believe that finding out the right process by diagnosing the causes of impasse is the most important thing I do. So every major mediator I've ever known always agrees, whether they call it guided choice or not, agrees that it's all about finding the right process, because the dynamics of every dispute are different. The people are different, their psychology is different, the issues, the experts. So you really need a mediator who starts out by analyzing the causes for the impasse and then helps the parties get a process to resolve the issues, and then starts the negotiation. It was a great presentation, Jeremy.
Yeah, I agree. It was a great presentation. 2 points. A mediator should always ask whether the parties have enough information to make a reasonable choice about settlement at the first discussion of mediation. And if not, how can they get it efficiently And it's not every piece of information you need for trial. The question I have for Jeremy is, the activities of the mediator here seem to go potentially quite beyond what is traditionally engaged for. For example, you mentioned possibly interviewing leaders in the organization and so forth. Do you have a different engagement arrangement or agreement with the mediator for this?
No, Judge, and just a standard mediation, clause, will do. And I think it's really just buy-in, if all the parties recognize the virtue of this approach, then, it's easy to have everybody cool their heels a little bit, not set the mediation date and allow the process to play out. But no, directly, there's no specific engagement agreement or anything like that. But, again, it's focused on process at the outset, where the parties are more likely to agree on things that are uncontroversial, where they can have a feeling of control. And so I would ask Paul, what his experience is, but I think that it's a traditional mediation agreement, but then after there are the confidential discussions and the diagnosis and the establishment of what the process should be, that is where I think that you would almost see a codification of, it might be just email bullet points or something like that, a light codification of the idea of what is going to happen, and so maybe that is kind of an adjunct to a traditional mediation agreement.
Thank you.
It's Dan. Excuse me. You're saying that you can just use your normal mediation clause in your contract, which I certainly agree with. And where you have folks on both sides that are open to this principle, I think you could get there pretty easily. But my question is, from a drafting perspective, have you ever seen a mediation clause that sort of forces or at least pushes this concept forward? Because I think many of us have been in situations where the lawyer on the other side isn't somebody that maybe has ever been exposed to these concepts, and so they're more resistant. And I wonder if having a contract clause to sort of use as a hammer would be helpful.
That's a great question, and one of the creative things that I've seen done, and these are on the big EPC projects, the $1 billion projects. I've seen some very smart people who I used to work for getting agreement at the contract drafting stage about the identities of certain mediators, because those mediators are going to run the process no matter what we want. That's just they run the best practices. They're going to do it. The way that they have found is the most successful way of doing it. And so, identifying the people who might be acceptable mediators can be an advantage. I think that, if Paul were to chime in, he'd say that generally you want a dispute resolution clause to be as general and broad as possible, so there are not reasons for people to argue that it doesn't apply. And I think it's one of the challenges for getting people to agree to mediation, certainly pre-mediation clauses in contracts, is all of our reluctance about, we don't know what kind of dispute it's going to be, right? I mean, there's certain kinds of disputes I'd rather be in court, others I'd rather not, and I think trying to prejudge what a mediation would look like and to put a lot of constraints on it is something that would be a challenge. And so, when I feel like it's essential that I have a guided choice mediator, and I imported a mediator in from a couple time zones a year or two ago where I was dealing with, it was a professional malpractice claim against a design professional, and the other side was making a policy limits demand on the CGL policy. And it's just like, oh my God, they don't even understand the difference between the kind of insurance that's likely to respond. I went out and I got a mediator and I said that we're going to have to stop this ship steaming at 50 knots and turn it around. And I didn't look for the buy-in of the other party because I'd never get it. They weren't going to buy in. They didn't understand the key issues. So I went out and I found somebody. I was lucky that the other side found her to be appropriate. And we had a wonderful mediation that led to a resolution. So it's best with everybody's buy-in. It's possible even if you don't have the buy-in of everyone. But to answer your question directly, no, I don't think anything special in a pre-dispute dispute resolution clause, the kind that we negotiate in the contracts. I'm not in favor of doing anything unique.
Jeremy, thank you for a great presentation. I think it's possible, and there's an opportunity to use many of the guided choice principles as a party advocate without calling for a formal mediation. What I've been doing for the last 3 years is creating a project collaboration platform where I, as a party advocate, along with other counsel and representing other parties, inject themselves into weekly project calls, with the owner, with the general contractor, designers as needed, and project subs as needed. When you do that, your schedule, you lose control of your schedule, but you're able to guide the group using the mediation techniques which you've outlined, without the formal mediation, to say that we can forensically engineer the cause of the defect, or we can creatively and collaboratively process the insurance claim. And it's been very successful early in projects, like you point out. But interestingly, it's almost a pre-mediation step, which requires all the principles you've discussed and a willingness of the participants under confidentiality agreements to fully engage candidly on all of the issues that are pending on a project. And I think it's work intensive for in terms of the litigators here, not thinking that it's going to be good for business. It's very intensive for weeks and months, and it's a process that's been successful. But it's based on what you've outlined here, I think, in large part.
Yeah, Greg, and I think that we both come from the school and nip it in the bud. And on those, mega projects, certainly, dispute resolution board or something similar can be very useful, But everything that I have covered today, I think it's the blinding flash of the obvious. I'd be surprised if anybody on this call learned anything really new. And the question is why isn't there more adherence to this? I think that it's sort of like the doctor that smokes cigarettes. I don't know why this isn't widely accepted and understood, but I think its day is coming. I think that there will be greater adherence to these kind of principles.
Jeremy, on an optimistic note, across the country in the mediations I'm handling, this is essentially the approach that's being used. In the kind of construction cases that we all have, with multi-parties, complex, larger dollars, I'm finding that lawyers around the country are all essentially buying into what you're saying, particularly with respect to we don't want to mediate until we have enough information to mediate. And sometimes the case is far enough along that you already have the discovery, and then other times you don't. And then we really do talk about, how do you get there? We don't want to do everything you would do for trial, but we got to do enough. And that's not easy to talk about, but I'm finding people around the country are very ready to have that discussion.
Yeah, Cliff, it's Alex. I think that's really important. You said it early on when you got to evaluate those risks. Just like we want to, hopefully in our contract drafting, allocate those risks as best we can to the right people. In this case, you're not going to get that insurer to the table on the mediation negotiation of the valuation part until you can give them that clear risk analysis. So I do think this process is something that the lawyers across the country are happy to do, but it's essential that you get to that risk analysis. Otherwise, you're never going to get your insurer to the table.
Well, this has been great, and I really appreciate the opportunity to weigh in. And I want to tip my hat to Paul Lurie, who has never had a conversation with me over the last 20 years where 50% of it wasn't discussing guided choice mediation. So, Paul, you're a great friend and mentor. Thank you for allowing me to ride shotgun with you on this guided choice process.
And thank you, Jeremy, for a great presentation.
Thank you.
Thank you, Jeremy.
Thank you. Thank you very much.
Thanks, Jeremy.
Thanks, everyone. Hope to see you all at the happy hour on the 9th.
Thank you, everybody. Great seeing you.
Bye-bye.
Bye-bye. Great
Bye.
presentation, Jeremy. I'm sorry. How are you?